Welcome back to Open Line. We are talking with elder law attorney Tim Takacs. We're talking about wills, but anything when it comes to caring for a loved one, planning for financially for caring for an aging loved one, or yourself even.
Yeah.
But wills, we've had several calls.
Yeah, and you mentioned Jennifer called and said, well, they moved, and it sounded like maybe they were kind of young, and it was like noisy there, and wherever it is that she was calling from. And that kind of got us. We're talking through the break about, well, how do you, I think you asked, well, how do you change a will? Is it as simple as, do you write on it, or do you, have a sheet of paper that, you attach to it and whatever? And it's so that kind of, got me thinking about, stuff that we've seen. And I know one case that we had, many years ago, probably 15 years ago, I had a lady that walked in, and she brought in it was a will that was printed out on a 9-pin dot matrix printer. Those of you who are old as maybe as I am know what those are. And it had maybe 6 or 7 pages, and so she brought it in and said, well, this is my mom's will, and it's got writing all over it. Right. Not just like the 9-pin dot matrix printer. It had stuff where who were scratching out here, and she changed this name over there, and she'd done this over there, and whatever it was. And it's okay. So I says, okay, so we'll go to, in fact, it was, at that time, Judge Clement was the probate judge in Nashville, in Davidson County. So I, presented it, so we petitioned the court to admit mom's will to probate. And I gave Judge Clement the original will, and I said, well, Your Honor, as you can see, that there's writing and scratching and, attempted erasure marks all over it. And I said, well, Your Honor, in my opinion, I think that I think the court should ignore anything that's been written on that.
Oh, no.
And the judge says, I agree.
Oh, no. Well, that's
well,
rough.
And here's the reason why is that, okay, so who made all those scratches?
Sure, they could have made it in the car ride over. Yeah, somebody could have just.
Who erased that? It was not. There was not initialed. And it was one of those things where the judge goes, and he was right. Is that there are the right ways and the wrong ways to make changes to estate plans.
Right.
And you can imagine that there are people out there that would see, oh, I didn't realize that mom had left me out. And so the next thing you know, people are erasing things or tearing things up, or who knows, and it's who knows, who did that,
right?
And so the best evidence of what mom intended, or what we knew that she intended, was the original document without any scratches on it at all. And it was, and there was nothing on there that you could not read. So it wasn't like there were certain parts that were obliterated and you just, well, we don't know what this word says.
Right.
I mean, you could see everything that had, that was a part of the original will, and that's what Judge Clement did, and that was the right thing to do.
And so generally speaking then, it's not enough, well, it's obviously, it's not generally speaking, but it's just not enough to just make a quick little note on a will.
Right.
If you're going to change it, take the time to get it typed, to do it right.
And there are the right way, like you've heard me say before, is, what we very seldom, and in fact, I can't think of the last time that we did it, where we actually had, made a bequest of personal property in a will. People walk into our office, and they say, well, I want to leave my, my great-grandmother's diamond ring to my niece, and I want to leave the quilts to, my daughter-in-law and all this other stuff. And I go, we don't put that in your will.
Right.
Because that's the stuff like that comes and goes. People change their mind, people give it away before they pass away, maybe it gets lost or broken or something else happens, and then they pass away, and then, the daughter-in-law goes,
where are the quilts?
Where's my quilts?
Yeah.
And the next thing you know, she finds it in, her sister-in-law's house, and she's going, well, you stole my quilts. It's like, no, Mama gave those to me. Well, they're right here in the will. I was supposed to get them, and I mean, that's the kind of stuff that happens.
Right.
And I've seen estates get, I saw one estate probably 25 years ago, and I just flabbergasted because a $10,000 estate, and that bunch spent thousands of dollars arguing about personal property.
Yeah.
And that's what people tend to argue about. So what you do is when you want to make a specific bequest of personal property, then don't put that in your, like your typewritten document that you had the lawyer do. Write it out on a separate sheet of paper. You sign it and date it, and say, I give the following, I give the following items to my niece, whoever it is, the name, and maybe you do 1 page per person. Mm-hmm. As long as it's in your own handwriting and signed and dated by you, then that's what we call a holographic codicil to your will. That's the technical term, because holographic means it's in your own handwriting. Okay. Codicil means it's an amendment or an attachment. Okay. To your will. See, in the old days, like the really old days, there was no word processing, right? Sure. Right. So you would walk into the lawyer's office, and the lawyer didn't have typewriters either. They actually handwrote stuff, and they didn't want to have to handwrite your whole will all out again. So they would write out, codicils to it. So you might have codicil number 1, codicil number 2, codicil number 3, because there was no word processing where you could just throw the whole thing away and retype and do a new one. That's where that came from. And of course, and also people weren't as literate as they used to be. Right. So you would go to the lawyer's office because, maybe you couldn't read and write very well, but you knew the lawyer could. Yeah. So that's how that stuff happened. And you can do the same thing with personal property. As long as it doesn't, and that's why you want to avoid contradicting, what's already in the original document.
All right, let's take another call here before we go to break. Let's go to Ivan. Hello, Ivan.
Hello.
Hello, go right ahead.
Approximately 20 years ago, my mother made a will leaving everything equally to her children.
Okay.
Suppose one of the children dies. Mm-hmm. A couple of years later, my mother dies. Then what happens to that will that was originally left to all 3 children? Okay,
so one of the children dies, and then mom dies later. Now, what happens is that will is still in operation, and that means that when mom died, if let's say, okay, she left her estate to the 3 children in equal shares, it means that the child that predeceased her, his or her share goes to his or her children.
Oh, really?
Yes. So let's say that Susan died, and she was survived by 4 children. Then her 4 children would share in her inheritance equally. That's just as a matter of law. Now, maybe mom's will says, and this doesn't happen very often, but if you leave everything to the to the 3 children in equal shares, most of the time it says, it's implied that if a child predeceases, that child's share goes to his or her children.
Or wife.
Or right. No, not to spouse.
It wouldn't go to spouse.
It wouldn't go to spouse. It goes to children.
Okay.
You have to specify if mom wanted to do something different, if she could say, well, if my daughter Susan predeceases me, I leave her share to her husband, or if any of my children predecease me, then their children do not inherit, and then it's divided equally between my 2 surviving children, which means the last person standing gets everything.
Right.
But that's not typical. It does happen, but it's not typical that people want to do it that way.
So Ivan, I'm just curious, is that what you thought, or what is?
Well, that's sort of what I was afraid of, but it turns out that one of her children is in serious physical health now. I think she will probably die before my mother. Mm-hmm. Brother and I are taking care of my mother, who has severe dementia. Mm-hmm. That might last a long time.
Yeah.
Yeah.
Okay.
Right. So now, one of those things there would be for instance, her mother, apparently she's got severe dementia. She may not be able to change her estate plan.
Right.
because of the dementia. If she dies before the daughter does, in other words, so mom dies and she is survived by the 3 children, and one of the children is seriously ill, I mean, it could be that maybe that child's inheritance, would be at risk for that child's medical bills.
Right.
We've talked about that before. Is that's why, the will of, okay, I leave everything to my children in equal shares is maybe not always a good idea, because children sometimes go, I don't really need to inherit stuff. Because if I do, it's going to go right to my creditors. It's going to go right to, I'm going to lose public benefits. There could be a lot of reasons why, which is one of the things that maybe, Ivan needs to think, is there some planning that he needs to do?
All right, let's take a break. Thank you for that call. Thank you for others. If you want to call in, there's the number, 615-737-PLUS, 615-737-7587. Take a break. Be back right after this.